Well, I don't understand the state's argument to depend on the proposition that the executive must detain everybody, even if it doesn't have the capacity to detain them. I understood their argument to be centered on something quite different. So let's just assume, for the sake of argument, that there isn't an issue about how many people you were going to detain, but only a question about which ones you were going to detain. And the problem that I see with your final memorandum is that Congress has established its own set of priorities and has said that certain categories of aliens must be detained, shall be detained. And the final memorandum tells ICE officers, don't do that. Don't detain anybody based solely on that person's criminal history. You must make a totality of the circumstances decision about every single alien who you're considering for detention. Isn't that correct?
No, that's incorrect. And let me be really clear about how the guidelines operate with respect to detention. They don't govern the question of continued detention at all. They're focused on apprehension and removal, and therefore, when DHS officers have someone in custody and there are pending removal proceedings, the guidelines leave it to the statute to dictate those kinds of detention decisions, and DHS does treat 1226C2 as mandatory in that circumstance.